So, so more specifically with law, wanted to hear more from you about what the law interviews are like. I know that they're different between each of the colleges and each college. I mean, there's probably a huge similarity, but they have autonomy of how they do the interviews. But at least in Trinity Hall, what can a student expect in a law interview?
I think for every single interview season I've ever done here at Trinity Hall, both interviews have involved specific exercises. They almost always both involve pre-reading. Not exclusively. In the pandemic, we didn't set pre-reading exercises, so I wouldn't want to be taken as giving any cast iron guarantee that we'll never again do an exercise without pre-reading. But it's much more common at Trinity Hall to set pre-reading and then interview on that exercise.
And is that reading that you do just before the interview?
Mm-hmm. Yeah, that's very important because we don't expect any prior understanding of law.
Okay.
You don't need to know anything about. I mean, it's helpful to kind of have a sense as to like what the law is as a general concept. But, if you're applying for, I guess, politics, you might not have studied politics at A level, but you should have a sense of what politics is. But beyond the sort of baseline level of, there's some reason you want to apply to do law and you understand that it's, the law provides rules and guidance which helps adjudicate between conflict, resolve conflict between individuals or create systems in which people are enabled to do things. I mean, even that's like way more technical. I would never expect a student to say that to me in an interview, but that kind of,
Impressive that you managed to just give a very one-line definition of what law is.
Well, I mean, I could hear in the back of my head like, oh, all my colleagues say about that. What about this? But, we really don't expect any kind of understanding, like prior understanding of law to do well in the interview. You don't need to study A-level law. So what we will give students generally is maybe a fake statute, a fake piece of legislation, whether it's a criminal offence or something related to contract law or tort law or land law. And possibly we might give them a factual scenario in addition to read, or we might just give them the mock statute. And then with that kind of exercise, if there isn't a factual scenario on the page, then a factual scenario will be presented to the candidate in an interview. And what we're looking for is, has the student understood the statute, what it does, the effect of the provisions? By provision, I just mean sort of, there'll be like number 1, section 1, and then maybe there'll be subsections A, B, C, something like that. I should say subsections will be numbered and then paragraphs would be A, B, and C. But, do they understand what the subsections or the individual paragraphs do? What effect they have? Are there tests contained within the statute? So, for example, criminal damage, for example, the actual criminal damage statute provides a definition of what constitutes criminal damage in English law. A person commits criminal damage when they intentionally or recklessly damage or destroy property belonging to another. So can they identify, in order to commit criminal damage, which components within this test are necessary? Are there alternative options at any stage? So intention or recklessness. You don't need to both intend and be recklessness. It's sufficient to either intend or be reckless. So it's comprehension, really.
It sounds like
understanding what the text is doing, close attention to detail.
Could you explain for the viewers and for myself what statute and means and what you mean by test?
Yeah, good. So when Parliament makes law, they enact a statute. We would say that they enact a statute or a piece of legislation. So the Criminal Damage Act. It's embarrassing, isn't it? I can't just list statutes. What have I been teaching this week? The Offences Against the Person Act, the Police and Criminal Evidence Act. So you can, all of this legislation is available free online. So you could Google all of those pieces of legislation I've just cited and see it all as it was enacted, and if it's been later amended, you can see the more recent versions. And you can look at, if you want to go and look at Section 1 of the Criminal Damage Act now, you'll see that definition of criminal damage that I just gave. And some pieces of legislation are more complicated than others, of course. But that is the way in which Parliament makes law. So often we will give students either a real piece of legislation or a fake piece of legislation. And then we're looking at how well a student understands how that piece of legislation or how that fake statute is structured, what it does, how to satisfy the. Oh, you asked me to. What's a test
as well?
Yeah, good.
That was good. We should go back onto that as well.
Yeah, well, this leads me onto it. I think if say the statute is concerned with what. Let's say we've got a fictitious statute, which is concerned with whether or not a contract is valid, right? There might be a test for validity, or it might be that the statute provides a number of concepts or factors that would invalidate a contract. And for each invalidating factor, or I should say vitiating factor, really, if I'm in the world of contract law, for each vitiating factor, there's a test to establish whether that particular vitiating factor is present on any set of facts. And so what we would want students to do is to look at that statutory language, the language used in the statute in detail, to try and figure out what is the minimum I would need to prove on any set of facts to determine that this vitiating factor is present, and therefore, the contract can be unpicked.
So am I right in thinking that applicants might be expected to both look at how credible the legislation is in terms of how it's structured, like how good is it as a piece of law?
Well, so that's a separate question, and I think this distinction is really important, because when we're engaging in an interview around, say, a fictitious statute, often what we'll be asking students to do is apply that statute to a set of facts, and then the question is just, how does the statute work? What does it do? And can now I know what the test is now, because I've identified the test for.
I see.
The kind of deception that might vitiate a contract, kind of misrepresentation that might vitiate a contract, and I have a set of facts, and I need to figure out whether these set of facts sort of whether it matches, if you like, whether I can establish this kind of test, satisfy this kind of test on the facts. But the student might think that's stupid. Right. That's a terrible test. That doesn't really feel like intuitively, that doesn't match my kind of pre-existing understanding of what deception is, or I feel like this gives me a really weird answer that just looks on its face wrong. The listening part's important here, right? Because if the interviewers asked you to apply the statute to the facts, you need to do that. And if you think, but that seems really surprising to me, share that. Because in law, there are different kinds of skills that we deploy as part of our legal reasoning, and application of the law as it stands to the facts is one test, and critical evaluation of the law is another. And the separation of the two is really fundamental to good legal scholarship and being a good student. And it's something that I've been reiterating to my first years week on week in supervisions. It's something that I'm trying to teach them. It's tricky, especially when the law's complicated, to pull those two things apart. But we'll definitely be looking for that in interview. Yeah,
because I guess there's two non-ideal situations where you're pulled more towards the critical evaluation, and that's stopping you from kind of applying it and doing it. And then on the other side, if you're doing it and applying the law, but you might get into the trap of never critically evaluating, does it actually make sense?
Exactly. And I think, the interviewers will have a sense of what we want to test in that interview, and
Mm.
the one interview isn't the whole part of the picture. So our aim is to use every aspect of the application process to together and holistically test the range of skills that we want. So it may be that someone goes through an interview and doesn't necessarily engage in very much critical evaluation of the law.
It's a short interview.
Because it's a short interview, and we might be focusing that year on other on other kinds of skills in that interview. But certainly it's fair game, if you like, for us to be asking, and what do you think about that? Do you think this is the right kind of outcome? Why not? Well, okay, if the law sort of works in this way, how would it then also apply to this kind of case when we change the facts a little bit? Would you get the same answer? Would you get a different answer? Okay, and what do you think about that? Does that make sense to you? Do you think that that's desirable or undesirable? And can you explain a little bit why you think it is or isn't desirable?
Nice. So just to put it in layman's terms, to go through it one more time. So am I right in thinking that like an applicant, not always, but most of the time, would be expected to comprehend a piece of law and then understand when it will be acted on, how they'll have a set of facts, and then they'll see whether the law will be acted on these facts.
Yeah, whether it would apply to those facts. Yeah, absolutely. And then that would be the beginning of the interview, really. Okay. And then we'd start tweaking the facts and changing them, inviting candidates to think about whether the law as it's provided does draw certain kinds of distinctions. What kinds of distinctions does it draw between different kinds of cases? When are cases similar, such that the law would apply in the same way? Another word we would use for that is analogous, but so similar that you'd apply the law in the same way. Or when are they so different that the law ought to be applied in a different way? When would we distinguish between the two cases is another way of putting that point. And then we would, I think, often build to that kind of critical evaluation. How can you use your instincts and arguments about what you think we're trying to achieve here, what we should be trying to achieve here, the consequences of applying the law in one way versus another way, to form a view as to how best these potentially quite ambiguous provisions should be understood, or whether these provisions which aren't ambiguous are just wrong. Or I shouldn't say are just wrong, but what I mean is are undesirable and should be changed, and what might that change look like in order to better achieve those purposes.
So I believe, so is the second interview any different to like the structure of the one we've just been talking about?
It's very similar usually. And again, there's no guarantees that we're always going to do the same kind of structure every year, but we don't have a general interview. It's it's not going to be we're not going to ask you, why do you want to I certainly have never asked a candidate, why do you want to study law? I personally have never asked that question in an interview. I don't remember, so far as I can recall. We want to see your enthusiasm and curiosity and interest in the subject, but there are other ways, I think, of identifying that on your application, and other things I want to be looking at looking for in an interview. So other exercises we might give if you've had a mock statute exercise in one interview. There are other kinds of exercises that we do. Something that again would involve pre-reading. So all the pre-reading is done sort of on the day of the interview, immediately before the interview for a set period of time, and then you come straight from that pre-reading into the interview. So we might give you an extract from a case, from the Court of Appeal or the High Court or the Supreme Court, House of Lords, if it's an older case. And that will be an extract. It might be a little bit amended, it might be edited, but we'd be testing quite similar skills, but just in a different context. So can you identify relevant from irrelevant? Do you understand comprehension skills? Do you understand what this is about? why it seems to be important, what aspects of the text seem to be more significant than others. Are there particular legal tests or definitions? Is there an argument being made for a particular view in this passage? And if so, what reasons are given in support? Can you identify counter arguments and why, let's say, the judge, if we're looking at an extract from a case, why the judge found that counter argument unconvincing, what reasons were given to reject it? Do you agree with the reasons given? Do you find the argument compelling? Do you think something's been missed, or do you think the reasoning is in some way kind of disconnected from the claim that's been made? Like it doesn't quite support the point, that the evidence given or the arguments given doesn't quite support the point. So I think, reflecting critically when you've got a sort of longer piece like that, which seems argumentative, whether it's from a case or maybe it's from an article, maybe a legal article, a legal academic article, or it could be from a newspaper or something like that, an argumentative piece. Do you agree with the argument? Candidates certainly should be thinking much more critically about that from the get-go. And I would expect those kinds of questions. What do you think we should be doing here? Why do you think this is a good argument or a bad argument? To be more dominant in an interview of that sort, often, not always, but often.
So is that one much more, not to just kind of describe it in one short sentence, but a comprehension of a text?
Yeah, I mean, comprehension's important in both because you can't figure out how a statute should be applied to facts if you don't understand, if you aren't able to really pay attention to the detail of how that language fits together to create an effect. But again, I think it's a different kind of comprehension challenge. When we set an extract from a case or an extract from a newspaper article or a journal, an academic journal article or something like that, often candidates are facing a wall of text that can be quite intimidating, and it will be complicated. The language will be complicated. It will be unfamiliar. It will be challenging. To rise to the challenge, you've got to sort of breathe, compose yourself, embrace the challenge. Ring words that you're uncertain about, but try and draw inferences about the meaning of those words from the surrounding context. Well, I don't know for sure, but based on the way in which this word is situated within the paragraph, my best guess is it probably means something a bit like this. And then you can ask for clarification. You can explore that uncertainty with the interviewers, and if it becomes relevant in the discussion.
Am I right in thinking that in the first interview, when you're trying to see if the piece of law applies, that kind of exercise, there's a element of problem solving alongside the comprehension critical analysis, but in the second interview there's less of an element of problem solving?
Sometimes it can be that way, but another way in which law is made and developed in this jurisdiction, a common law jurisdiction we call it, is through appellate decisions. So if the Court of Appeal when the Court of Appeal decides a point of law, that decision becomes authoritative. The judgment, if you like, becomes law. And so sometimes this element of problem solving can feature in these interviews too. It depends a little bit on what the nature of the extract is and what the nature of the questions that we ask might be. But I think across the two interviews, we're testing similar skills in different ways. Do you have a close attention to detail? Can you identify the claims that are being made in a piece of text, reasons in support of that claim? Can you apply tests to facts? Can you draw distinctions by identifying relevant differences? Can you see where cases are analogous, to go back to that word I defined earlier, where cases are so similar they should be treated in the same way? Can you identify, is this a strong argument or is it a weak argument, and why? Can you take on new information, synthesize it, work with it, see why you might need to adjust your view because of that new information and the significance of that new information? Or can you see where actually that new information doesn't change my view and shouldn't, and explain why? And those skills can be tested across the interviews. And as I say, we haven't always set interviews with pre-reading, but even in the interviews where we haven't set pre-reading, there's still been some kind of exercise involved. It might be, here's a kind of legal problem we might face. Can you give me a definition of this concept which might help us solve this problem?
Yeah, I think it's more of a revealing of like my thinking beforehand, because I think I'd always seen like the sciences as like a problem solving area, and the humanities as like a critical analysis area where you kind of sit back and take apart the text, whereas it seems like in law the consistent, they're both married together.
Yes, you get the best of both worlds, Sion, if you come and do law.
You never can like rest on your laurels and just be a critic, because you have to then see how it's applied, and you're also expected to know
exactly
how to solve the problems of what you've just suggested, I guess. Like you can never like just do one.
Yes, I think that's right. I mean, I certainly don't expect candidates in interview to solve the problems, but a desire to explore that in a structured, reasoned way. And the interview itself will provide that structure if you listen to us and answer the questions that we're asking, and not the questions you would rather we were asking. Because often people feel more comfortable in what I call the doctrinal analysis.
Okay.
So what I mean by that is, here are the rules that are provided in the law as it currently stands. Possibly those rules are sometimes ambiguous, and we've got to do a little bit of work to figure out how we think these ambiguous rules should be interpreted, and then we're applying them to the facts. Then there's the more critical, the sort of humanities side of the study, if you like. What should the law be? What principles and values ought to underpin the law, and how would we change the law to better reflect those values or to better achieve those ends? So what I see in students, certainly when they're on the course here at Cambridge, is some people are naturally more comfortable in one of those areas than the other. But one of the reasons why law is such a, I think, rigorous degree, but also such a fantastic preparation for all kinds of professional lives thereafter, is you've got to get good at both. You've got to do both. You can't really engage critically with what the law should be if you've got no idea what it is. And just understanding what the law is, I mean, I don't want to say it's boring. It's not. I think it's fascinating. I love the kind of black letter problem solving type stuff that we do, but there's so much more to the study of law than just that. And some of the really big questions that we explore, both on the course and sometimes at interview, is sort of what makes this really special, I think, and particularly what makes it special to study law at Cambridge.
Yeah, and the skills will make you highly employable for like almost any career, not just with being a lawyer. You'd be showing that you can both digest large amounts of text, but also problem solve.
Yeah, absolutely.
So with these exercises and interviews, like, do you have any tips for like upcoming applicants of how they can like prepare for them if they can?
Yeah, absolutely. I think there's a couple of, let's divide it into two, because I think there are tips I can give when you are actually in the interview itself, which are more specific and tailored and concerned with managing those exercises beyond the sort of general points I was saying earlier. And then there's sort of, how do you prepare with those exercises in mind? So a couple of very basic tips for handling the exercise side of things in the interviews. Read them really carefully. Take notes. People like to read and take notes in different ways. Some people like to, print things off and do it all by hand. Some people are very comfortable, taking notes on a document on their computer. But have a sense of which you prefer, and make sure that your interview is taking place in an environment where you're able, if you need to be able to print it off, make sure that you've talked to your school or you've got access to a printer, so you can do that. If you don't have access to a printer, you can't get access to a printer, maybe practice taking notes on a document on your computer, so that the interview isn't the first time in which you've ever done that. So read them carefully, take notes, and then have that visible during the interview. It's not a memory test, right? We want students to be referring back to that material during the discussion, and it's not at all a problem for students to say, "Oh, can I just go back and look at let me just take a look," and then sort of physically look at the document. Or often we know that we've got students flicking between windows when they're on Zoom, and that's fine because we want them to be reading that extract that we've sent to them. And that's really important because language matters. We were talking about attention to detail earlier in the sort of comprehension sort of skills that are on display. Sometimes when I have read something and I paraphrase it, it can be very easy to subtly change the meaning of the test, the provision, as I would say in legal terms, just by changing some of the words in which I use to summarize that point. And it's very important that we try and avoid that as lawyers. And so it's a skill that we're looking for in our law candidates, that they're able to very precisely and accurately identify. I think I just hit the microphone. Right. That they're able to very precisely and accurately identify those legal tests. And if you're not looking at the material enough, I mean, you don't want to be like this through the whole interview, right? Yeah. But if you're not referring back carefully, you might miss what we call a gloss that you've put on the language, so a way that you subtly changed the meaning of the language. So feel free, if you're unsure, to refer back to the material, so you can make sure that you have remembered that sentence or that form of words, that phrase, if it's really important to get it precise, that it is sort of we're working on the kind of the basis of the text as it's written, not the text as we've half remembered it to be. So read, take notes, have that in front of you. And then, when you're doing that reading, I mean, bearing in mind all of the sort of skills that I've said that we're testing, as you're going through, and what do you highlight? What do you pick out? Are there any tests? What are the component parts of that test? Do you have components within that test, all of which are necessary? Are only some of them necessary? Are there alternative ways of satisfying this test? Are there reasons given? What argument is being made? What claims are being made? Statements about what the law is or what the law should be. Are reasons given? Are identifying the counter arguments, and just sort of flagging what these moving parts are, so that you can more quickly find the right part of the extract to help you support the answers you want to give to your interviewer in discussion. So that's sort of like in the room. During in your room, wherever you're interviewing during the interview. I think some tips for managing that. What was your other question?
So that would be tips for during the interview, but for students who are like leading up to the interview, how can they prepare? So
how to prepare
the weeks beforehand, the months beforehand.
I think some people find it difficult to have a mock interview. Maybe there's no one in their life or at their school who's able to give them a mock interview. No, they don't know anyone who's ever had a Cambridge interview before, and there can sometimes be a fear that like this is going to be really detrimental. I don't think that's the case at all. I had a mock interview before my interview at another place, and it was nothing like the interviews that I had when I was a student there. So I think I wouldn't worry too much about that, because there are some really helpful things that you can do. Read a lot, and read challenging material. I mean, look, don't get me wrong. I love a sort of easy read novel, at the end of a tough week. But it's good to have something that just like washes over
exactly,
you.
Yeah.
But that's not very good interview prep, right? You've got to read things that you find difficult to understand, and grapple with it, and really try and focus and make some headway there, because that will help you develop the kind of comprehension skills. So, non-fiction books, good quality journalism, if you can find any. There's lots of good quality journalism out there, actually. You just need to, look in the right places. So good quality journalism, non-fiction books, material that you need to think about. Now, you don't have to read loads and loads and loads and loads and loads of it. What matters is what you do with the stuff that you're reading, because being a passive reader of this kind of information isn't going to be good interview prep, right? Take take an article or a chapter or a section of a chapter and imagine this might be something you're given an interview, right? What might your interviewers ask about it? What's this chapter about? Or what's this passage about? What's this article about? What argument is being made? What reasons are given in support of that claim? What kind of evidence is being used to support the argument? Do you think the argument is persuasive? Why? Why not? If it's on a political topic or something like this, what should we be trying to achieve in this particular area? Why do we tax people, and what is the purpose of inheritance tax? And, what are the sort of issues that we're facing and trying to cure with this budget? And is this a good way of solving the problem, for example, right? There's all sorts of material you can read, which is really helpful in that regard. And it's great if you've got someone else to talk to about it, but you don't need that. Some time.
Write notes.
Write notes. Test yourself.
Yeah.
Have another go. Have another go. Yeah. Have another go. And the more you practice this, the more being faced with, or the less likely it is you will be thrown by a piece of challenging text on a subject you've never considered before. Yeah. If the first time you've ever really had to think about how, what is this argument? What are the reasons given in favor of it? What do I think of it? On a topic you just like, what even is that? If the first time you've ever had to do that is in an interview, then it's going to be more challenging than if you've had a bit of practice on that. But you can do that on your own with an internet connection or the school library.
And the notes app just to type away.
Exactly. Yeah, exactly. So that, some breathing exercises, if you are the kind of person who experiences nerves and anxiety, that's absolutely no barrier to success, either in the interview, in the applications process, or as a student here. What's going to help you? Some breathing exercises, that kind of mindfulness practice, and building it in regularly, so that you're sort of increasing your resilience to stress in the run up to what is inevitably going to be a challenging, sort of stressful process, is possibly a good idea for everyone. So testing the setup. If the first time you've ever been on a Zoom call is in an interview, that's going to increase the stressfulness of the situation. So, just get a friend or a classmate or someone to give you a Zoom call. Yeah. And then there are books you can read, like Letters to a Law Student, What About Law? We've got the University of Cambridge has an Exploring Law course that was set up by some colleagues in the law faculty, and I worked on the criminal law module. Professor Stephen Watterson, who's one of the directors of studies here, was leading on sort of putting that course together. And so there's a strong Trinity Hall presence in the Exploring Law course, but I think that's quite good preparation for sort of thinking about law. Students probably will be encouraged to read these books when they're thinking about how to apply to law, but there'll also be information in those books about, or in those resources, about the kinds of skills that are helpful both as a student and as a candidate in the applications process, and are themselves quite good ways of honing those skills. I did a lot of Sudoku when I was applying for law.
Oh, really?
Yeah, I did. Yeah. I taught myself how to do Sudoku because it's just logical reasoning. Right?
Yeah.
It's
nice.
Problem solving.
Oh wow, that it helped you.
Yeah, exactly. Just trying to think critically.
Yeah.
Any ways of improving your critical thinking, I think, is really helpful.
Yeah, I think you want to be in a position where you can recognize and feel that critical thinking in any aspect is transferable. And I think once you kind of get that and feel that, then it will help you for your law interview.
Exactly. It'll help you for the rest of your life.
Yeah, exactly. Whereas I think it's if you're in a position where you've compartmentalized these things as separate to each other, then you want to realize that critical thinking, like learning how to play Sudoku and getting good at that, that kind of problem solving will help in
Yeah.
other aspects, like
Yeah,
your law interview.
I think that's right. When I was a teenager, you wouldn't know now you wouldn't guess it now, I'm sure. But I was a football referee. I used to referee football.
Oh, really?
Yeah.
Nice.
And I think it was great preparation for a law degree, because all it is rule application, right? Like, that definitely is offside, and I'll tell you why. And I appreciate you don't think it is, but that's irrelevant. See you later. Crack on.
So when they shout at the ref, nothing changed.
Nothing changes. Yeah. Never let them see the whites of your eyes.
Oh, that's great. That's amazing how that is just entirely
Totally transferable.
Yeah, exactly.
Yeah.
Amazing.